that it can deny the existence of facts which are universally recognized. How then could we proceed to perform the mandate given us? It was said in last year's Democratic platform, and here are the words, if these problems cannot be effectively solved within the Constitution, we shall seek such clarifying amendments as will assure the power to enact those laws adequately to regulate commerce, protect public health and safety, and safeguard economic security. In other words, we said we would seek an amendment only if every other possible means by legislation were to fail. When I commenced to review the situation with the problem squarely before me, I came by a process of elimination to the conclusion that short of amendments, the only method which was clearly constitutional and would at the same time carry out other much-needed reforms was to infuse new blood into all our courts. We must have men worthy and equipped to carry out impartial justice. But at the same time, we must have judges who will bring to the courts a present-day sense of the Constitution. Judges who will retain in the courts the judicial functions of a court and reject the legislative powers which the courts have today assumed. It is well for us to remember that in 45 out of the 48 states of the Union, judges are chosen not for life, but for a period of years. In many states, judges must retire at the age of 70. Congress has provided financial security by offering life pensions at full pay for federal judges on all courts who are willing to retire at 70. In the case of Supreme Court justices, that pension is $20,000 a year. But all federal judges, once appointed, can, if they choose, hold office for life, no matter how old they may get to be. What is my proposal? It is simply this. Whenever a judge or justice of any federal court has reached the age of 70 and does not avail himself of the opportunity to retire on a pension, a new member shall be appointed by the President then in office with the approval, as required by the Constitution, of the Senate of the United States. That plan has two chief purposes. By bringing into the judicial system a steady and continuing stream of new and younger blood, I hope first to make the administration of all federal justice from the bottom to the top speedier and therefore less costly. Secondly, to bring to the decision of social and economic problems younger men who have had personal experience and contact with modern facts and circumstances under which average men have to live and work. This plan will save our national Constitution from hardening of the judicial arteries. The number of judges to be appointed would depend wholly on the decision of present judges now over 70 or those who would subsequently reach the age of 70. If, for instance, any one of the 6 justices of the Supreme Court now over the age of 70 should retire as provided under the plan, no additional place would be created. Consequently, although there never can be more than 15, there may be only 14 or 13 or 12, and there may be only 9. There is nothing novel or radical about this idea. It seeks to maintain the federal bench in full vigor. It has been discussed and approved by many persons of high authority ever since a similar proposal passed the House of Representatives in 1869. Why was the age fixed at 70? Because the laws of many states and the practice of the civil service, the regulations of the Army and Navy, and the rules of many of our universities and of almost every great private business enterprise commonly fix the retirement age at 70 years or less. The statute would apply to all the courts in the federal system. There is general approval so far as the lower federal courts are concerned. The plan has met opposition only so far as the Supreme Court of the United States itself is concerned. But, my friends, if such a plan is good for the lower courts, it certainly ought to be equally good for the highest court, from which there is no appeal. Those opposing this plan have sought to arouse prejudice and fear by crying that I am seeking to pack the Supreme Court and that a baneful precedent will be established. What do they mean by the words packing the Supreme Court? Let me answer this question with a bluntness that will end all honest misunderstanding of my purposes. If by that phrase, packing the court, it is charged that I wish to place on the bench spineless puppets who would disregard the law and would decide specific cases as I wished them to be decided, I make this answer: that no president fit for his office would appoint, and no Senate of honorable men fit for their office would confirm that kind of appointees to the Supreme Court. But if by that phrase the charge is made that I would appoint and the Senate would confirm justices worthy to sit beside present members of the court who understand modern conditions, that I will appoint justices who will not undertake to override the judgment of the Congress on legislative policy, that I will appoint justices who will act as justices and not as legislators, if the appointment of such justices can be called packing the court, then I say that I, and with me the vast majority of the American people, favor doing just that thing now. Is it a dangerous precedent for the Congress to change the number of the justices? The Congress has always had and will have that power. The number of justices has been changed several times before in the administrations of John Adams and Thomas Jefferson, both of them signers of the Declaration of Independence, in the administrations of Andrew Jackson, Abraham Lincoln, and Ulysses S. Grant. I suggest only the addition of justices to the bench in accordance with a clearly defined principle relating to a clearly defined age limit. Fundamentally, if in the future America cannot trust the Congress it elects to refrain from abuse of our constitutional usages, democracy will have failed far beyond the importance to democracy of any kind of precedent concerning the judiciary. We think it so much in the public interest to maintain a vigorous judiciary that we encourage the retirement of elderly judges by offering them a life pension at full salary. Why then should we leave the fulfillment of this public policy to chance, or make it dependent upon the desire or prejudice of any individual justice? It is the clear intention of our public policy to provide for a constant flow of new and younger blood into the judiciary. Normally, every president appoints a large number of district and circuit judges and a few members of the Supreme Court. Until my first term, practically every president of the United States in our history had appointed at least one member of the Supreme Court. President Taft appointed 5 members and named a Chief Justice. President Wilson, 3.